Good afternoon, everyone, and welcome to this month's Employee Benefits Compliance webinar. As we are kicking off here, you will see a couple of polling questions pop up on your screen. We are looking to gauge your organization's approach to health plan fiduciary oversight and responsibilities. With recent legislation like the Consolidated Appropriations Act and related litigation making headlines, health plan fiduciary responsibilities are under the spotlight, and we are curious about your company's approach. So thank you for taking a moment to answer those two questions while I provide a couple of other pieces of information about our webinar today. So again, welcome to our webinar. I am Jenny Badeau with Assurex Global. Today, the team from Loomlight will cover the most common employer questions. Thanks to those of you who submitted your questions during the registration process. We saw a lot of common themes throughout those questions that were submitted, and our team will address a lot of topics throughout our time together. And you may have noticed a new name, Loomlight. BenefitComply is now part of Loomlight, so you'll hear that name moving forward. The same team that you have come to know will still be leading our webinars, and we will be welcoming some new faces as well. And as we're kicking off here, we would also like to extend a special thank you to your local insurance benefits advisors and consultants who are partners of Assurex Global for making today's webinar possible. And we do welcome your questions today. So if you have questions at any time throughout the presentation, please submit those over to our experts using that Q&A function at the bottom of your screen. They will address as many of those questions as they can during the next hour. And if you're just joining us, you'll see a couple of polling questions up on your screen. Please take a moment and provide your responses. And I will also remind you, we do record our sessions, so a link to the recording as well as a copy of the presentation slides will be available early next week from the benefits advisor who invited you here today. And I will also drop a link to the presentation slides into our chat section here in just a couple of minutes. I'm going to leave the poll up for just a few more moments. It looks like a few more responses are still coming in, and we want to be sure to capture those. And again, as always, thank you for responding to our polls. We do publish the results of these polls in various formats, including our monthly market check surveys, which are usually published right about a week out from each month's webinar. They're a great way to get a timely pulse on how other employers are approaching and thinking about various employee benefits issues. So let me close out our poll, and I will share the results out with everyone so you can kind of get a preview of what those responses are. But again, keep an eye out for that market check survey if you kind of want the full details. All right. So you should be seeing our responses here. It looks like some of you do have a formal committee in place. A lot of you kind of have an informal group or maybe one person who's responsible for that oversight. And some of you haven't taken any steps yet, or maybe are unsure of your company's approach. And then you can see there the various topics that folks are really focused on as part of those reviews. So again, thank you as always for taking a moment to respond to our polling questions. It is very much appreciated. But with that, let's get into today's content. Joining us from Loomlight are Regan Devon, Delaney George, and Dan Brady. Regan, I will turn it over to you.
All right. Thanks, Jenny, and thanks for having us here today. Like Jenny said, Loomlight now, but still kind of the same consulting team that has been attending and putting these on for you. And we're looking forward to this particular session. We take hundreds of employer questions every month. And so that's really how we decided to build this out, as well as I know that many of you wrote in when you were registering for this webinar and gave ideas for the types of topics that it might be helpful for us to address. And so we really have a packed agenda today. You can see that we've got 9 different categories that we're going to touch on. What that really means, because we could probably do a webinar on each of these separately if we really wanted to go into all of the details, that's not really the intention today. It's to pinpoint some of the specific questions that we get around this, or the most common questions that we get, and to give you some general information about that. It's really going to touch broadly across lots of different employers that we may have in the audience today. Small employers, large employers, whether you offer fully insured or self-funded benefits, there are pieces of this that probably affect all of you. And so hopefully you'll find that helpful. What we encourage you to do as we go through today, hopefully as we're going through, you're nodding your head and saying, yep, okay, I understand, we've got that handled. But if there's anything that we go through that you're not sure of, you need more information, you say, gosh, I understand, but we don't have a solution for that, or we're not doing that today. Those are perfect opportunities for you to reach back to the Assurex Global partner that invited you here today to get further information and clarification, and to potentially help you find some different solutions if that's what's needed. So with that, I'm going to kick things off. I'm going to take the first 3 questions that we pulled together, and then I will turn it over to my colleague, Dan Brady, another one of our senior consultants, and then we'll wrap up with Delaney George. She's going to take the last bulk of this. As Jenny mentioned, please feel free to send in comments and questions throughout, and we'll try to get to as many of those as we can as well. So with that, first question that I want to throw up is, what notices have to be distributed to employees, and what are the distribution rules for those notices? We're going to focus specifically on the federal notice requirements. So these are all federal notice requirements that are in place under a variety of different requirements that apply to benefits. So ERISA, COBRA, ACA, HIPAA. We could have categorized all of the notices in this chart by where they came from in the law. But as we work with employers, the way that they're often thinking about this is when. When do we have to distribute these? And so what we ultimately found is that it would be helpful to have this chart that we created here, where it provides a list of the federal notice requirements that you need to be delivering to employees and potentially their family members at the times that they're required. So some of the things and posters and general notices have to be provided to everyone when they're first hired. That's that first category. The second category is when they're newly eligible. So this is not going to be all employees, but those who are actually eligible for your benefits. And most of these are tied to your group medical plan or your group health plan coverage. Those are the notices that have to be provided when they're first eligible. Then they repeat in a lot of cases, but a little bit different list that we have to provide annually during open enrollment, probably as part of your benefits booklet or your annual notices packet that you give to everyone as they're going through open enrollment. And then we've got a few that are just at random times because they're tied to timeframes that aren't specific to enrollment, or they're tied to a specific event. For example, a COBRA election notice that goes out when there's a qualifying event and they lose coverage. That's really what that last category is. The color coding on here helps you identify the places where they overlap. So in the green, the notices that are required when they're first eligible and then upon some other time frame. Most of them that are doubled up are required both when they're first newly eligible as well as annually during their open enrollment. And so that's where a lot of times what many of you have is an annual notices packet. It is okay to combine most of these notices into a packet and provide them together. They don't have to be each separately delivered on their own. They don't even necessarily have to be on separate pages. So a lot of times you'll have that. You'll maybe even work with your broker to help create that. If you don't already have that, or if you want to double check things, use this as a sort of checklist to look at your packet and make sure that all of the notices that are applicable to you are included. We did include some of them in here that are only specific to certain circumstances. For example, the grandfathered status. If you don't offer any grandfathered options, that one wouldn't be applicable to you. You cross that one off the list. There are a few state level required notices, but the reality is that most of them are more so HR, employment law notices, that not specific to benefits. So most of what you have to think about and be worried about from a notices perspective would be these that we've got listed at the federal level. Once you have sorted out which notices need to be distributed, then you need to settle on your distribution method. Hand delivery is an option, although not used very often, especially anymore, with so many employees being remote. Mail is the second option and perhaps still the most common, but definitely moving more and more employers toward delivering electronically, which is the third option. The thing that you have to be careful about with the delivering them electronically is there are still some restrictions around this, and the DOL has not actually updated these requirements in a long time. So it will be nice when they do that, and I think we'll probably get even more flexibility around electronic delivery, but for now, this is what we've got. And so we have to determine that employees meet one of two requirements to be able to provide the notices electronically. If they have regular access to your electronic system as part of their everyday work duties, then you can deliver everything electronically. So individuals that go in and sit in a cubicle or in an office and are directly tied into your electronic system every day as part of their job, maybe even a phone that you're providing and that is directly connected to your systems, that would count as well. But there are employees that don't have that they're driving, they're working in a factory on parts, and they don't have direct access to your electronic system as part of their work. And in that case, if they don't, then in order to be able to provide the notices electronically, you have to obtain their consent. The way that a lot of employers will do that is either in their employee onboarding process, they could get their consent during that time, or they could even do it, since so many of the notices are tied to benefit eligibility, don't do it for all of the employees, but instead do it when they're newly eligible as part of their enrollment paperwork, that they would fill out a consent where it lists out the types of notices that you'd be providing, where they will get them, how that will all work, and then they ultimately consent as part of that process. And you don't have to do that every year. As long as you do it once you've got that consent in place, then it's okay, unless they would revoke that in the future. So assuming they either have regular access to your system or they consent, then you can provide the notices electronically. You can certainly push them out via email. That would be an option. What we see more and more often is that employers are making these available on their intranet, or they're putting it on their benefits portal or their payroll system. That's a really nice way to do it, a really easy way to update them as needed. But just posting them in those places isn't enough. You have to take one extra step if that's how you want to handle the distribution. Once they're posted on your internet or other portal, you have to send out a communication either by mail or text or email, somehow reaching out to those employees and letting them know that the notices are posted and available. And then when you update them in the future, doing the same thing, letting them know that when you go through open enrollment the next year, now we've got the new notices, everything's been updated, here's where you find them, and that you can get a paper notice upon request. Most of the time, these notices, the distribution can be satisfied by delivering it simply to the employee, and that will be seen as a delivery to the spouse and dependents as well. So just making it available to the employee will be enough. The one to really be careful of is the COBRA initial notice. So that's the one that often we recommend that not be part of your annual notices packet, or even if it is, that you also mail out a copy to the family. And then if you mail it to their home address, as long as you know that they don't live at different addresses, then that will be more likely to be received by not only the employee, but family members as well. All right, the next question I want to touch on is, when should the Form 720 be filed for self-funded plans required to pay the PCORI fee? And this deadline is just right around the corner, so we have lots of employers asking questions about this particular process. The deadline is July 31st of this year for any plan years that ended during 2024. So when we're thinking about the PCORI fees, first of all, we have to determine which plans are subject to this fee. It's most group health plans, but not accepted benefits. So not limited dental, vision, health FSA. They wouldn't be subject to this fee. It's primarily major medical plans, a retiree-only plan if you have that, and HRAs. There are lots of different types of HRAs. If it's an accepted benefit HRA, or an HRA that's only available to reimburse dental and vision, just like the other accepted benefits, it wouldn't be subject to the fee. But any type of general purpose HRA, post-deductible HRA, an individual coverage HRA, I know there are more employers out there offering ICHRAs, they would all be subject to the PCORI fee. If you offer only fully insured group health plans, your plan is subject to the fee, but the carrier is going to take care of it for you. Probably bake it into the premiums that you pay, but ultimately the carrier is going to tally the average covered lives, report the fee on the Form 720 and pay the fee, and you don't have to do anything. If you offer a self-funded group health plan, whether it's your group major medical plan or an HRA, which is a type of self-funded plan, then you owe the PCORI fee. And it's not typically the TPA or the administrator that's going to handle this on your behalf. Certainly could, but that's not what we often find is the case. Typically, the employer of those plans has to go ahead and file the Form 720 and report and pay the fee. Your TPA may help you with counts for covered lives to help you do the calculations, but then they won't actually do the form preparation and submission for you. When we think about this fee, the way that it's calculated is we do average covered lives over the previous plan year. And then that gets multiplied by the fee for the year, which is approximately $3 per covered life. So for most employers, this is a very small amount of fee that's ultimately due each year, but needs to be done on behalf of those self-funded plans. As I mentioned before I even jumped to this slide, the way that the due dates work that's just a little goofy is we have to look at when the plan year ended. So if the plan year ended, a self-funded plan year ended sometime during 2024, then the fee is due now by July 31st of 2025. And we use the Form 720, it's a quarterly excise tax form. We use the second quarter form, so they just recently released the updated form. It's dated June 2025. If you look at the revision date for the Form 720, that's the one you want to be using. And then regardless of when your plan year ended, when you're filling out that Form 720, complete it for the second quarter ending June 30th, 2025. That's what you want to fill out in the initial part of the form. And then you jump down to 133 and you use either line C or D depending on when your plan year ended. The last question I'm going to address is about state continuation, taking lots of questions on when does it apply. So the answer here is that it applies solely to fully insured plans. Self-funded plans due to ERISA preemption are not subject to state level requirements in most cases, and that includes state continuation. So if you offer only a level funded or a self-funded group health plan, you don't ever need to pay attention to state continuation. But if you offer a fully insured plan, you have to follow the state continuation requirements for the state where that policy was issued. So it's not about where the employee works. It's not about where the employee resides. It's all about where that policy was issued. For example, if you offer a fully insured plan issued by the carrier in California, you have to follow COBRA requirements. That's the state continuation in California. And you have to follow that regardless of where employees work or reside. It's always going to be COBRA that applies because of where that policy was issued. When we think about the interaction between federal COBRA and state continuation for fully insured plans, any plans that have 20 or more employees are going to have to follow federal COBRA. And that's true whether the plan is fully insured or self-funded, both. Any employer that is offering a group health plan and the employer has 20 or more employees, they have to follow federal COBRA. The state continuation, at first at least, was kind of put in place as a gap to cover those really small employers that might be offering group health plans. So a fully insured plan offered by an employer with less than 20 employees, those are the employers that are typically subject to the state continuation. And so they kick in where federal COBRA wouldn't and provide some level of continuation option. It really varies greatly from state to state. Some don't have it at all. Some it's only 3 months, some it's more like 18 or 36 months, similar to federal COBRA. So you really have to look and see what your particular state requires. And then in some cases, it's not instead of, but it's in addition to, or it runs concurrently with. And so in those cases, we'll use COBRA again as an example. COBRA provides 36 months of state continuation. And so under federal COBRA, a lot of times it'll only be 18 months. And then at the end of that, what COBRA says is for a fully insured plan issued in California, when that 18 months of federal COBRA is exhausted, then COBRA kicks in and gives the individual another 18 months. So all that being said, if you offer a fully insured plan, Look at where that policy is issued. Make sure that you're familiar with the state continuation requirements in that state to make sure that you can communicate that correctly and provide whatever notices and administration is required. Dan, I think you're up.
Yeah, thanks. So the next topic is how does Medicare eligibility impact employee benefits? And before we dive in, I do want to kind of make one important distinction that I think is often overlooked, and that is the difference between being eligible for Medicare and being entitled to Medicare. An individual is eligible for Medicare based on their age, disability, or ESRD, but the individual is not enrolled in Medicare and the Medicare coverage has not become effective. This is different than entitlement to Medicare, because when an individual is entitled to Medicare, then they are both eligible and enrolled, and their Medicare coverage is effective. And the reason this distinction is important is because some of the rules that we'll touch on in a little bit will apply whether the individual is both eligible and entitled, or simply only when they are entitled to Medicare. So we wanted to highlight a couple of the kind of key topics where Medicare and employee benefits collide, and we could spend an hour on each of these alone. So we just kind of want to give a high-level overview and some background information. I'll touch on the Medicare secondary payer rules in a little bit. So moving along to Medicare Part D creditable coverage. So just a little bit of a background. Employers offering prescription drug coverage have to determine whether the coverage they offer is creditable and communicate that determination to both eligible employees and then separately report the information to CMS. It's a little bit complex, but generally the coverage is creditable if the actuarial value of the coverage is equal to or exceeds the value of the prescription drug coverage under Medicare Part D. And why this is important, why it matters, is that individuals become eligible for Part D when they enroll in Part A or B, but they can delay that Part D enrollment if they have other creditable coverage through their employer. And if they delay that coverage, their Part D enrollment for beyond 63 days without creditable coverage, then they can face late enrollment penalties when they do eventually enroll in Part D. One question that we get all the time is whether employers are required to offer creditable coverage, and the answer to that is no. And there actually is no penalty if you don't offer creditable coverage. So that's something to keep in mind. Moving along to COBRA, a question that we get all the time is, whether enrolling in Medicare is a qualifying event. And in most cases, the answer is no. And this is because of the Medicare secondary payer rule. So Medicare entitlement is a listed qualifying event in the COBRA regulations, but for employers subject to the MSP rules, the plans are prohibited from terminating coverage simply due to an individual being eligible or entitled to Medicare. One situation that we see that is often administered incorrectly is when an employee voluntarily drops the employer coverage due to enrolling in Medicare. The spouse and dependent do not or are not entitled to an offer of COBRA coverage. This is because the coverage is not lost due to Medicare enrollment. It's due to the employee voluntarily terminating coverage. There are also election timing considerations. If a covered employee or qualified beneficiary becomes entitled to Medicare before they elect COBRA, so let's say they enroll in Medicare and then a few months later they terminate employment and elect COBRA, the employer is still obligated to make an offer of COBRA and provide the COBRA coverage as normal. If, however, a COBRA election takes place before the individual becomes entitled to Medicare, then the plan by design can terminate that COBRA coverage early. But this would not impact the COBRA coverage for any spouses or dependents who are also covered. We get a lot of questions about extensions for COBRA coverage. There is a special rule for spouses and dependents where if the employee experiences a qualifying event of termination of employment or reduction in hours within an 18-month period after they enroll in Medicare, then the spouse and dependent, but not the employee, are entitled to an extended COBRA period. And that is going to be for the remainder of the 36 months from the date the employee became entitled to Medicare and not the qualifying event date. Cafeteria plans. So Medicare entitlement or a loss of Medicare eligibility are events that permit employees to make mid-year pre-tax election changes under the employer's cafeteria plan. For example, if an employee becomes entitled to Medicare, they may make a prospective election change to cancel or reduce their employer coverage. If they lose Medicare eligibility, they can elect or increase their coverage under the employer's group health plan. Individual coverage HRAs or ICRAs. So there's a general rule that paying for or reimbursing an employee's Medicare premiums is not permitted. This creates what is referred to as an impermissible employer payment plan that does not comply with certain healthcare reform requirements. There is an exception or option. If the ICRA rules are followed, then the employer can reimburse Medicare premiums through an ICRA. And I'll touch on HSAs in a little bit. So under the Medicare secondary payer rules or MSP rules, these are federal regulations that are designed to protect Medicare beneficiaries and ensure that group health plans appropriately coordinate benefits with Medicare. So as the name suggests, the rules mandate that in many cases, the employer-sponsored group health plan pays first and Medicare acts as the secondary payer. So you can see a chart here based on the group health plan status. In many cases, we're looking kind of at that 20 plus employee category and age-based Medicare, in which case the group health plan pays primary. For retiree or COBRA coverage, Medicare is primary, except when it's ESRD-based Medicare. So in addition to the coordination of benefit requirements, the MSP rules also provide certain protections for Medicare eligible and entitled individuals. One of those requirements is the prohibition from taking into account Medicare entitlement of a current employee or a current employee's spouse or family member. So the plan cannot limit benefits, terminate coverage, charge higher employee premiums for an employee or family based on their eligibility for Medicare. There is another kind of age 65 requirement that's often overlooked, and the MSP rules require that plans provide current employees and their spouses who are age 65 or over with the same benefits under the same conditions that are provided to employees and spouses under 65. So we get a lot of questions, can we charge higher premiums for employees who are age 65 plus and their spouses? And for employers subject to these MSP rules, the answer is no. And then finally, there are some incentive-related rules as well. The MSP rules prohibit employers from offering financial or other incentives to encourage Medicare-eligible individuals to decline or terminate the employer coverage in favor of electing Medicare when the employer-sponsored coverage would pay primary. So this would prohibit offering certain opt-out incentives based on Medicare eligibility or paying Medicare premiums and supplemental premiums. And then just to wrap up, so Medicare and HSA eligibility, this is another topic that creates quite a bit of confusion. And I mentioned that distinction between eligibility and entitlement, and that's really important here. Merely being eligible for Medicare does not make someone ineligible to establish or contribute to an HSA. So someone who is age 65 plus, who is not enrolled in Medicare and is otherwise HSA eligible, can continue to contribute and receive employer contributions to their HSA. In addition, a spouse's Medicare entitlement and resulting HSA ineligibility does not impact an employee's HSA eligibility. It's sort of figured as individual coverage. So the employee will still be able to contribute up to the family contribution limit if they have family HDHP coverage. And then funds from the employee's HSA can still be used to reimburse HSA ineligible spouses qualifying medical expenses as well. One other kind of topic related to HSAs that employers should always be aware of is in some cases, Medicare will apply retroactively for up to 6 months if the individual delays their Social Security benefits. And that 6 month retroactive period of Medicare does impact HSA eligibility. So it's advisable to either stop making HSA contributions prior to enrolling in Medicare, or just to be sure that you're calculating your maximum contribution for the year accordingly. All right, next topic. Employee is on a leave of absence. How long should benefits continue? So the two most common questions we get are, an employee's on a leave of absence. Do we have to continue providing group health plan coverage? And the other question is, when should we terminate coverage and offer COBRA? Anytime we get that question, I kind of like to put forth this flow chart, if you will. And step one is generally to determine whether the employee is entitled to protected leave under state or federal law. So, for example, FMLA. If they are not, then the next step is you move to the employer's plan documents and SPD to determine whether they address eligibility for coverage during a leave of absence. And then third, you need to determine whether the employer has its own leave of absence policy that also speaks to benefit eligibility during leave. You want to watch out for inconsistent language between a leave policy and a plan document. If none of these apply, and let's say the employee no longer satisfies the plan's eligibility rules, then generally their coverage will terminate and COBRA should be offered. The primary issue that we see regarding leave of absence and benefit eligibility and coverage is that if an employer continues to allow an otherwise ineligible employee to remain on the benefit plan, in almost all cases, the carriers and stop-loss vendors will refuse to cover any claims that otherwise ineligible individual incurs while they're ineligible and on leave. So this is certainly a situation where no policy is bad policy. Just want to make sure you're reviewing leave policy and plan documents to ensure that they do address leave and how benefits will continue. The third most common question we get regarding leave is, if an employee is on leave and they're going to continue benefits, how should they pay for coverage? So again, we're kind of focused on whether it's protected leave under FMLA or unprotected leave. If the leave is paid, then in any situation, employees are going to continue to make pre-tax salary reduction contributions through payroll. Coverage will continue as is and continue to be paid as normal. If the leave is unpaid, the FML regulations kind of provide three options for premium payments when coverage continues. And when leave is unprotected and unpaid, employers will typically use one of these three options as well. And those options are to prepay for coverage on a pre-tax basis. This obviously requires that the leave be foreseeable. To pay as you go on an after-tax basis, or to make catch-up contributions on a pre-tax basis upon return from leave. If employees are going to be taking leave for a significant amount of time and there is some concern whether or not they will be returning to employment after the leave, then that's a situation where maybe the employer does not want to permit catch-up contributions. It's not easy to track down former employees who have terminated and owe months of premiums. And there are pros and cons to each of these options. And again, having a clear process and to communicate that payment process prior to leave as possible is ideal. Whether the leave is under FMLA or just the employer's policy, the general requirement is that to continue coverage, the employee has to continue to make their share of the premium contribution. If the premiums are not paid, then coverage can generally be terminated, and termination for non-payment would not be a COBRA qualifying event. If the leave is under FMLA, then there are some specific grace period rules and notification requirements that apply prior to terminating the coverage. And it looks like we just got a question about that. So if the employee is on leave and they're not paying premiums, then generally coverage would terminate for non-payment, and there's no obligation to offer COBRA One thing to be aware of, though, is if you are going to allow employees to make catch-up contributions, that you're not terminating their coverage um, in that situation, because obviously they'd have a right to make the contributions after the leave is over. So the last topic that I'm going to cover is, are we required to offer coverage to domestic partners? There is no requirement under federal law to offer coverage to domestic partners. Really, the key question here is whether the plan is fully insured or self-insured. If the plan is fully insured, um, then it's possible there are applicable state laws that require domestic partner coverage. And so that's certainly a situation where you want to reach out to the carrier and discuss domestic partner eligibility. The plan is self-insured and subject to ERISA, then any state mandates that apply to domestic partner coverage are going to be preempted. And it's really then up to the employer to decide if they want to extend coverage to domestic partners and how to define domestic partners. Um, some common eligibility requirements. Again, if the plan is fully insured, then the carrier may already have these definitions laid out, as there could be state requirements that have a specific definition. If the plan is self-insured, then employers are pretty much free to define domestic partner and set restrictions. We kind of have a list of common eligibility restrictions here. It's important that if you are extending coverage to domestic partners, that these eligibility requirements are clearly and uniformly applied and stated within the applicable plan documentation. Um, you can require that employees attest or certify before enrolling a domestic partner that they are in a legitimate domestic partnership. And that's a pretty common requirement that we see. And finally, with domestic partner coverage is the tax implications. So the general rule is that benefits can only be offered on a tax-favored basis to the employees and to employees' spouses and tax dependents. In most situations, a domestic partner is not going to qualify as a tax dependent for this purpose. They're not a qualifying relative or child. So in that case, the employer must treat the fair market value of the coverage provided to the domestic partner as taxable income to the employee. So how do we determine that fair market value? For single employees, it's going to be the employee cost for COBRA coverage. In some cases, you can use the incremental cost of adding individuals to determine that amount. So let's say the monthly plan cost for single coverage is $400. Employee plus one is $700. You would take the difference. The fair market value would be the difference of $300. The rules do require you to assign a value to the domestic partner coverage, even if there is no additional cost, such as when an employee has family coverage and it wouldn't cost any more to add an individual. And then step two is going to be to impute that fair market value into income. So most cases, the employee pays the domestic partner premiums on a post-tax basis, and then the employee will receive income imputed to the fair market value of the employer share of the premium for the domestic partner. If the employer paid the entire amount, then the value of the domestic partner coverage is included in the employee's income.
It's okay. I'm going to pause there just real quickly, Delaney, before you jump in. We did get a few questions. One going all the way back to the PCORI section that I covered. There was a question about counting covered lives when we're doing the fee. Good question, because it differs depending on what type of plan we're talking about. If you are counting average covered lives for a self-funded group medical plan, a traditional group health plan, then you have to count all covered lives. It really is a belly button count. And you do an average over the year. There's a couple different ways that you can count that, but you're not counting just the employee or the primary subscriber, but you're counting their spouse and dependents as well. So it's total lives. There is a special counting rule, though, for HRAs. So, for example, if you're only paying for the HRA because you offer it alongside a fully insured plan, the fully insured plan is going to be taken care of by the carrier, but you have to pay the fee for the HRA, then you only have to count kind of what we would think of as a primary subscriber, the employee or the retiree that is enrolled in that plan, and you don't have to count their spouse as independent. So just make sure that you understand that special counting rule just for the HRA. Otherwise, you really are counting all covered lives and then multiplying it by the appropriate fee.
Do you want me to touch on these?
Yeah, and I wanted to do one clarification to Dan. I agree with what you said about non-payment, and that if it's terminated due to non-payment, that there wouldn't be a COBRA continuation right, because that's not a qualifying event. However, if it's during FMLA leave, then at the end of FMLA, there may even be a gap because you might terminate the coverage a month in for non-payment during FMLA. But if it's terminated due to non-payment and then they're not able to return to work at the end of FMLA protected leave, there is a COBRA event that's triggered at that time. It's specifically the end of the FMLA that triggers that separate COBRA continuation right.
Yep. And again, terminating for non-payment, if it is FMLA, I believe it's a 30-day grace period to make the premium payment, and then a 15-day advance notice requirement. If it's not protected leave, then it's really a plan design determination on when and if a grace period will be offered. Um, so can an employee who is over 65 and eligible for Medicare elect to sign up for Medicare and decline group health plan coverage? So yeah, I mean, if an employee is eligible for Medicare, they can sign up for Medicare and then decline the employer-sponsored group health plan at open enrollment. Or if the plan is subject to the MSP rules, it's possible that the employee could have both Medicare and employer-sponsored coverage.
And what Dan talked about, I don't know if this triggered your question, but he was talking about that the employer can't make that choice for the employees. They can't incent them to make that choice, and they can't take away that choice. But if ultimately the employer continues to make the group health plan available and the employee looks and says, between these two choices, I think Medicare is better for me for whatever reason, and they voluntarily make that choice, that's not a problem. All right, I think that's it. So Delaney, you're up for the final stretch.
Thanks, guys. Okay. Our first question is, we exceeded 50 FTEs, that's full-time equivalents, for the first time in February 2025. When do we need to offer affordable coverage, and when do we need to do ACA employer reporting? So what this question is really asking is, when does an employer become an applicable large employer, an ALE, that is then subject to the Section 4980H offer of coverage requirements, i.e. the employer mandate. And one of the first keys in making that determination is the fact that ALE status for a particular calendar year will always be based on the count of full-time equivalents of the previous calendar year. So if an employer has an average of 50 or more full-time equivalents during a particular year, then that means that the employer will be considered an ALE for the following calendar year. And that's true regardless of when your plan year is. ALE status is always determined on a calendar year basis. And then I use the term full-time equivalents. And what the term is really in recognition of is that you're not only counting your full-time employees, you're counting all of your employees. And just looking at the first two tips below, it really recognizes both of those, that you're not only counting all employees, but you're counting all hours of service for any employee that was employed during the year, even if it's just for one day. They're going to be counted for ALE status determination. So your first step in ALE status determination is to count the number of employees with 120 or more hours of service for each calendar month in the year. A weird distinction here is that for ALE status determination purposes, the regulations use the number 120 hours per month versus the actual employer mandate defines full-time employees as those with an average of 130 hours or more per month. So it's kind of an oddball distinction, but it's a good thing to keep in mind. So step one, you've got all of your employees with 120 or more hours of service. Then your second step, you're trying to account for all of those other employees who worked fewer than 120 hours of service. And what the second step does is kind of converts all of those employees into fractions of an employee. By counting all of the hours of service of all those employees for each calendar month and dividing by 120. That'll get you your fraction, your full-time equivalents of those employees. Third step, for each calendar month, you're taking the numbers from step 1 and step 2 and adding them together. And then finally, for the final step for each month, then you add up all of those totals for each month and then divide by 12 to get your monthly average of FTEs in the year. And if that number is 50 or more, for the next calendar year, you'll be an ALE. Before we move on, I want to touch on the last tip here. I touched on the first two, but the last one recognizes that for employers who are part of a controlled group, ALE status determination looks at the entire controlled group. It does not look at each employer member. So if a controlled group has 50 or more FTEs, then all of the employer members of that controlled group will be considered an ALE, even if that employer member itself has fewer than 50 full-time equivalents, because they are part of this controlled group, then they are considered an ALE. So, okay, going back to the original question for an employer that breaches 50 FTEs for the first time in February 2025, they're going to, so it is assumedly for the first time in February 2025. So obviously during 2024, they would have averaged fewer than 50 FTEs. So for 2025, they are still not an ALE. But then for 2025, assuming that they maintain at least 50 full-time equivalents for the rest of the year, then mathematically they're going to average 50 or more FTEs during 2025. Therefore, they will be an ALE beginning in 2026, and that is when their offer of coverage requirements will apply, when they'll need to offer that affordable coverage to their full-time employees and their dependent children. Importantly too, for employers who are becoming an ALE for the very first time, there is a 3-month grace period. So for this employer becoming an ALE for the first time in 2026, there's kind of a grace period where those 4980H penalties will not apply for January, February, and March of 2026. But they will start applying beginning in April. So as of April 1st, 2026, they need to be making those offers of coverage. Otherwise, they will risk those 4980H penalties. Then the ACA employer reporting, that's always due early in the year following. So since they're an ALE for the first time in 2026, they'll complete that reporting for the first time in early 2027 when they do report for that 2026 year and what kind of offers of coverage they made for that year. Okay. Next question we have is, what benefits should be included in our wrap document? How many Form 5500s do we have to file? What this question's really asking about is ERISA documentation. So we'll take a minute to look at the ERISA documentation requirements. So all benefits subject to ERISA are required to have a plan document and a summary plan description. And they each have content requirements, including a plan number for each benefit, plan year, the ERISA plan year, which is what Form 5500 deadlines are based on, eligibility rules for the benefits, the named fiduciary who will be acting in the best interests of the participants of the benefits, claims procedures, information about COBRA, HIPAA, all of these things that participants need to be aware of, including the participants' own obligations to exercise their rights, because it's important to have all that documented and communicated to those participants, because if they are not told of their obligations, then it's going to be a lot harder to enforce what they have to do in order to get COBRA or submit claims, etc., what have you. Okay, so default rule is that every ERISA benefit needs a plan document and a summary plan description, and that's true regardless of size as well, regardless of the employer size or how many enrollees you have in each benefit. So to be clear, too, a single document can serve as both the ERISA plan document and the SPD, so long as it's meeting the content requirements for each of those. And there's some pros and one con really to that approach, even though it is definitely the norm, and we'll get to that in a minute. But bringing it back to the original question, what benefits do we have in our wrap document? I want to make clear that a wrap document itself is not necessarily an ERISA requirement, but one of the main functions that a wrap document serves is to meet the ERISA content requirements for a plan document or SPD by so you'll have the certificates of insurance or coverage for each of your ERISA benefits, and then what a wrap document does is kind of fill in the ERISA blanks that certificate of coverage leaves for any missing required content and any specific to that employer terms that they'll want to insert in that plan document. So the wrap document wraps around that certificate to fill in any gaps so that it together makes a compliant ERISA plan document / SPD. Then to the second part of the question, how many Form 5500s do we need to file? The default rule is that every ERISA benefit needs its own Form 5500 filing. I mentioned, plan documents have to have the plan number, and looking at the visual does a really good job of demonstrating without a wrap document, each of those benefits will have its own ERISA documentation, its own plan number, and thus its own Form 5500. But the second function that a wrap document can serve then is to bundle all of those ERISA benefits into a single ERISA plan, meaning that only one Form 5500 will be necessary then for all of those benefits that are part of the wrap document. So which benefits need to be in my wrap document? All of your ERISA benefits, because then you're taking real advantage of the advantage of a wrap document, minimizing the number of Form 5500s that you have to file. In the next slide, I think we go through, yes. So I mentioned that there is one con to the single document approach with plan documents and SPDs, and that is that plan documents are not required to be distributed. Unless it's requested, they're never required to be distributed, whereas SPDs are required to be distributed at certain times, as you can see there. So by creating a single document that serves both purposes, you're having to distribute the plan document when maybe you didn't have to, but it's definitely the industry norm now that having a single document can just make it more streamlined too. So and back to the Form 5500 reporting. Form 5500 reporting generally is required for ERISA benefits that have 100 or more participants as of the first day of the plan year. And for benefits that are part of a wrap document, if any one of those benefits has 100 or more participants as of the first day of the plan year, then a Form 5500 filing does need to be completed for that ERISA plan wrap document. And it will include all of the benefits in that wrap document, even if not all of them have 100 or more participants as of the first day of the plan year. So it kind of, if one benefit needs the Form 5500, then the whole wrap is going to get that Form 5500. And then I mentioned the plan year is important for determining when that Form 5500 is due, which will be within 7 months of the end of the plan year. And then, yeah, with the wrap document, only a single Form 5500 is required. So one of the big pros of having a wrap document. And then our last common question today is, when there's a loss of coverage, who can enroll mid-year or outside of open enrollment? And can that employee change plans? So what this question is really getting at is HIPAA special enrollments. HIPAA special enrollments are the only instance when a plan is legally required to allow an individual to enroll outside of open enrollment. And there's a few ways that they can be triggered. One is acquisition of a dependent through marriage, birth, adoption, or placement for adoption, becoming eligible for Medicaid or CHIP subsidy, or what this question is getting at is certain losses of coverage can do it. And not all losses of coverage, but generally it's losses of coverage that are due to a loss of eligibility for that other coverage will trigger the HIPAA special enrollment. Not if it's a voluntary drop or a termination due to non-payment. Those losses of coverage will not trigger the HIPAA special enrollment. When there is a HIPAA special enrollment, though, generally that individual will have at least 30 days in which to request that mid-year enrollment. And keep in mind, 30 days is the statutory minimum of the HIPAA special enrollment period. It's possible that by plan design, the plan can be more generous than 30 days. So it's good to check your documentation for that, but at least 30 days. And then once that coverage is requested, it must be effective no later than by the first of the month following the request. And then back to the first question, who can enroll mid-year? When it is the employee who is losing coverage and triggering that special enrollment right, the special enrollment right is triggered not only for the employee who lost coverage, but also their spouse and dependent children, regardless of the fact that of whether the spouse and children also lost coverage. So they would be able to enroll mid-year even if they personally did not lose coverage. In contrast, when it is an employee's spouse or dependent who loses coverage, that special enrollment right is only triggered for the employee, even if the employee did not actually lose coverage, because their spouse or dependent lost coverage, they also have a HIPAA special enrollment. And that particular spouse or dependent who lost coverage will have a HIPAA special enrollment right triggered. And then finally, yes, they can switch plans. HIPAA special enrollees are generally entitled to select any benefit package that they are eligible for, meaning that they do need to be allowed to switch plans generally. So, okay.
All right, I know we're right up at the top of the hour. We did get a few more questions in, and I'm not surprised. We touched on so many different things today, but just want to encourage all of you again to reach out to your Assurex Global partner if any of these things kind of triggered questions or confusion, or you need some help with those, and they can help you with that. But with that, otherwise, I want to turn it back over to you, Jenny.
Wonderful. Thanks, team. And thank you again to our audience for tuning in. As Reagan mentioned, we weren't able to get to every question today, so please do reach out to that benefits advisor who invited you here today. If you would like to explore any of our topics further, or if you have a question that we didn't get to today. And also, as a reminder, a link to the recording of today's session will be available from that benefits advisor who invited you here today. And with that, that does conclude our time together. Thanks again for joining us, and have a wonderful afternoon.